Hello and welcome to Shook, Hardy & Bacon's Quick Hits webinar series. In this webinar, Ricardo Ampudia of Counsel in Shook's International Arbitration Practice will discuss the protection of businesses overseas from foreign government conduct, including some tips for businesses to keep in mind as they encounter trouble abroad. We want you to be part of this webinar. If you have any questions, feel free to type them in the Q&A window on your screen, and they'll go directly to Ricardo's inbox. Or you can always contact him directly through the speaker window. With that, let's go ahead and get started.
Greetings, everyone. My name is Ricardo Ampudia. I am an attorney at Shook, Hardy & Bacon, L.L.P's Global Arbitration and Litigation Practice. I will talk to you about foreign investment treaties and the protection they can afford to business owners operating a business in a country that is not their own. In this video, we will talk briefly about foreign investment protection treaties. We will talk about how they can protect business owners who have decided to venture overseas and the remedies that such treaties can provide, including monetary damages. We will also cover some common pitfalls that foreign business owners encounter in protecting their businesses. Investment treaties typically protect any business or asset, also known as an investment, held by a citizen of another country, also known as a foreign investor. The investor's country of nationality and the host country must be parties to the treaty. As of this recording, there are over 2,300 of these treaties worldwide. Many countries have signed these treaties with dozens of other countries, so in a given case, there is a chance that a foreign investor's country has signed a treaty with the country where the investor is operating the business. Examples of foreign investors are many and depend on the circumstances. Such examples range from the quintessential owner of a factory overseas, to real estate developers, to owners of an energy-related plant or facility, and of course, owners of shares of a company, other securities, and even intangible assets and intellectual property. Depending on the case, foreign investors typically do not include businesses that only engage in one-off sales operations. Business owners who did not set up an overseas operation and instead have a single purchase-sale agreement with another company overseas are likely not going to be considered investors for our purposes. Let's assume that you or your company made the decision to open a business operation in the country that is not your own. There could be several reasons why you decided to establish your company overseas. Maybe you saw an opportunity in an area that was previously unexplored, or maybe your profit margins were much better overseas than at home. But after some time, you or your business overseas started to encounter some problems caused by the host government. Maybe the government stopped paying you on your contracts with a state entity. Maybe the government changed the laws just to target you. Or, in the worst cases, maybe the government seized your business, destroyed it, or even began to persecute or attack you. What can you do if something like this happens? Depending on the situation, it might seem to you that you are at a disadvantage. The local, legal, or judicial system might be difficult to navigate. You might not be sure that the government will rectify its own actions, or the local courts will challenge their own government and protect you instead. Instead of relying on local courts and tribunals, you might prefer to have your case heard by an international tribunal that is independent and whose decisions are enforceable. In such situations, foreign investment treaties typically provide protection in two ways. First, these treaties provide broad standards and obligations on governments with respect to foreign investments. I will discuss some of those standards and obligations in the next slide. Second, and just as important, these treaties typically give business owners the ability to bring their claims to an independent arbitral tribunal instead of local courts. That tribunal is typically composed of independent international judges or arbitrators selected by the parties. The goal is to provide an impartial and independent process for a foreign business owner to bring his or her claims. The obligations derived from each treaty depend on the treaty's specific language, but you can see some examples up on this slide. They typically include protection against expropriation without fair compensation, temporary seizures of property, arbitrary or discriminatory regulatory schemes, sovereign decisions resulting in failure to pay on contractual obligations, cancellation or failure to issue licenses and permits arbitrarily, failure to provide basic police protection, imposition of arbitrary fines and penalties, arbitrary detention of business owners or employees, and many other acts or failures to act that negatively impair a business. Affected business owners can seek relief for the damage they incurred as a result of the government conduct. For example, they can obtain the fair market value of the seized or destroyed business, future lost profits, or the amounts invested into the formation of the business before the business was harmed. Business owners can also obtain moral damages depending on the circumstances of each case. Also, business owners can claim attorney's fees and costs of the arbitral proceedings. Typical cases run 2 to 3 years from the moment of filing a claim until the arbitral tribunal makes a decision, or in arbitration parlance, the tribunal renders an award. That award is typically enforceable against the host state through international conventions on the enforcement of arbitral awards. Awards can only be challenged on limited and exceptional grounds, such as when there is demonstrated corruption by at least one of the tribunal members. Although the price tag of an arbitration can be high, often between $3 to $5 million, including attorney fees, arbitrator fees, and other expenses, there can be litigation funding and alternative fee arrangements for high-value disputes involving $30 million or more in damages that have a high probability of recovery. So the protections, as we have seen, are quite significant. They include an impartial process and protections against a wide variety of conduct, and business owners can obtain valuable remedies for the damages they suffered. But one problem is that many business owners are unaware of foreign investment treaties and the protection that such treaties offer. Unfortunately, this happens even after business owners seek the advice of counsel in the foreign jurisdiction where their business is operating. Foreign investment treaty protection is a very unique area of international law, which is why it is important to consult with counsel with specific experience in this field. Also, some investment protection treaties might have prescription periods. Sometimes businesses miss these deadlines because they learn about their rights too late, if they ever learn about them at all. Finally, business owners should be careful about not doing anything in local courts that might inadvertently cause them to waive their treaty rights. For example, under some treaties, filing a lawsuit for money damages in a national court can result in losing the opportunity to file claims before the International Panel of Arbitrators. These are some of the reasons why it is critical to talk to counsel with specific experience in international treaty law quickly after problems arise. In fact, ideally, business owners should talk to international treaty law counsel before even establishing the business operation overseas to ensure that they are setting up their business in a way that maximizes their chances of protection if problems with local governments arise in the future. I hope this video has been useful. Of course, if you have any questions about it, please feel free to send me an email at rmpudia@shb.com. Thank you for watching.
And that concludes this Shook, Hardy & Bacon Quick Hits webinar. Please visit shb.com for more experienced insight on additional legal topics. Thank you, and have a great day.